Sit down, stand up.
This clock is
Narrow ribbon.
that one is slow.
This clock's late.
We'd like to welcome everyone to the November 26, 2007 meeting of the Salina City Commission. Will the clerk please call the roll?
Mayor Jelka,
Here.
Commissioner Larson,
Here.
Commissioner Peck,
Here.
Commissioner Perney,
Here.
Commissioner Vanier.
Here. We'd like to invite everyone to join us in the Pledge of Allegiance in a moment of silence. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. First item on today's agenda is a citizens forum, a time set aside for any citizen who would like to bring a matter to the Commission's attention that is not on the day's official agenda. Is there anyone who wishes to come forward for that reason? Seeing none, we will continue on. There are no awards and proclamations or public hearings today. So the next item on the agenda is the consent agenda.
Item 6.1, approve the minutes of November 19, 2007. Item 6.2, authorize submittal of applications to the Division of Water Resources for amendments to the existing water rights.
I have one quick question on agenda item 6.2. Could somebody explain the difference between a vested right and an appropriated water right?
I'll attempt to do that. The vested rights were in place before the Water Appropriation Act of 1945. After 1945, all of those rights are approved through the Division of Water Resources, so vested is just an earlier right.
Okay.
Does that answer that for you?
Thank you.
Where's Water District number 3? Sorry.
Sorry about that. It's to the south and west of Salina, Smolin, Assaria, that type of area, over towards Bavaria.
Thanks.
Is there no further questions? I'll entertain a motion.
Mayor, I'd move for approval of the consent agenda.
Second. Motion is to approve the consent agenda. All in favor signify by saying aye.
Aye.
Aye. Opposed, same sign. That passes 5-0. We will continue on with development business.
Item 7.1, application number Z07-18, requesting a change in zoning district classification from R3, C3, and PC3 to PC3 on property addressed as 309 and 313 South 7th Street.
Mr. Andrew?
Thank you, Mayor. Mayor, Commissioners, this is an application filed by D.L. Rogers Corp., the parent corporation for Sonic Drive-In, and they are the owners of the current Sonic Drive-In at 310 South Santa Fe, and that original drive-in restaurant, which is still there, was built in 1973, and back in 1977, when the city was comprehensively remapped, the Sonic Drive-In site was zoned C3, as was most of the block directly south of Mulberry. The block behind it on 7th Street was zoned R3, reflecting its residential use. Back in 1997, Sonic was able to purchase a property at 313 South 7th, and they used a portion of that rear yard area there to develop some additional employee parking. But that was really kind of a stopgap solution and didn't really improve the configuration of their site all that well. In 2005, there was much discussion with the City Commission about hospital expansion and a creation of a agreed-upon expansion area for the Salina Regional Health Center. And so there was an amendment that was approved to the comprehensive plan that identified an area as a desirable expansion area for hospital-related facilities. One of those areas was the block between Mulberry and South Street. So this area where Sonic is located is actually within an area that has been identified at least as desirable for hospital-related expansion. In 2005, one of the dwellings there at 313 South 7th was demolished. There was also a house purchased and demolished on 7th Street by the Salina Regional Health Center. So as a result of all these changes, there's basically one house left on that block of 7th Street, which is owned by the Sheffields. The applicants have a contract to purchase that property contingent on that zoning change being approved. And what they're trying to create here is basically a zoning lot that would cover these 4 lots that they could plan on zoning-wise to look at possible either expansion or redevelopment of the site. They have no immediate plans for new construction, but that's what they're looking for. This will not create a contiguous zoning lot for Sonic. There is a 10-foot platted alley that runs through this block between Santa Fe and 7th Street. There's also a 12-inch public sewer line that's located in that alley. And so a number of issues related to vacating that alley and relocating the public sewer line would need to be worked out before the site could be redeveloped as the site plan in your packet shows. The other thing we wanted to note, which is a companion item on this agenda, is that for historical reasons, the C3 district does not permit drive-in restaurants, but the Planning Commission has recommended approval of a text amendment that would include them as a permitted use in C3. The particular site we're talking about is a 50 by 120 foot lot, has a dwelling on it. The area to the north is occupied by a existing business, the Mr. Windshield, and then you have the Masonic Temple to the south. So that really makes west the only suitable location for expansion of the existing restaurant. Again, we wanted to note that it's not so much the zoning as it is the location of that sewer line and the need to find an alternative solution for the Masonic Temple. That will really be the driving question here. So Sonic will need to retain the services of an engineer to examine alternatives for serving the Masonic Temple. This is was a mixed-use area, and now with all the changes on 7th Street, pretty much the residential character that was there has pretty much been eliminated. So the C3 zoning would be pretty consistent with the trends that have occurred in the area. The water line in Santa Fe that's in place that serves the existing restaurant, that could serve any redevelopment of the site. The 12-inch sanitary sewer line will need to be reconfigured in some fashion to make that work. But the burden's going to be on Sonic to come up with those alternatives. Santa Fe is an arterial street. 7th Street is a local street. Currently, Sonic does not have any drive-in or driveway access to 7th Street. However, the existing Masonic Temple connects to 7th Street in their parking lot, and the conceptual plan that you have in your packets does propose a 7th Street access. As we noted, the comprehensive plan shows this as a future hospital medical expansion area. However, C3 zoning does accommodate many medical-related facilities, so C3 zoning is not in conflict with that. I think we want to reemphasize that even if approval of this request, there are going to be challenges and costs associated with the vacation of the alley and the relocation of the sewer line. And it may or may not be feasible for Sonic to redevelop this site if this rezoning request is approved. However, this is a necessary first step for them to be able to plan what their future is at this location. So they are going to have to look at some of those alternatives pretty seriously. The Planning Commission reviewed this at their November 6th public hearing, and they recommended that the planned commercial district be approved and that the preliminary redevelopment plan for the site be approved, subject to 3 conditions that are identified in page 6 of your report and included in the ordinance that's in your packet. If you concur with that recommendation, the appropriate action would be to approve the attached ordinance rezoning these 4 lots on first reading. If you disagree with that recommendation, you could return this back to the Planning Commission or deny the request if you have 4 votes to that effect. With that, I'd be happy to address any questions. We do have representatives of Sonic here if you have questions of them.
Questions of the staff report?
Dean, where are those 2 houses are no longer there?
Right.
That's correct. This is a photo from early spring 2005, and those have since been removed.
So where are the Sonic employees currently parking?
That lot. That little lot right there.
Okay, they are not parking at the end there of the Masonic Temple parking lot.
Not officially.
I'll let the manager address that. At the time that we were discussing that in 1997, they were not able to reach any agreement with the Masonic Temple about using that as overflow parking, and it was not encouraged by the temple. So that may have changed, but the idea of that area behind the house there on 7th Street was to create that for employee parking.
Any additional questions to staff? Seeing none, I'd like to open it up for any public comment, if there is any. Thanks. If there is none, we will bring it back to the commission.
Mayor, I'd move for adoption of ordinance number 0710423, approving application Z0718, requesting a change in zoning to a PC3 district, allowing for the expansion of the Sonic Drive-In restaurant site.
Second.
Motion is to approve ordinance 07-10423, which rezones property on 309 and 313 South 7th Street from R3 multifamily residential to PC3 planned shopping center. All in favor signify by saying aye.
Aye.
Aye. Opposed, same sign. That passes 5-0.
Item 7.2, application number Z07-15, requesting an amendment to section 42-282 of the Salina Code to allow drive-in restaurants as a permitted use.
Mr. Andrew.
Thank you, Mayor. Mayor, Commissioners, this is kind of a companion item to the previous item, was driven by that. We had some discussions with the representatives of Sonic Drive-In, and we discussed the options for tearing down the existing restaurant and redeveloping the site, and basically pointed out that the way the current C3 district regulations were written, if they tore the restaurant down, they wouldn't be able to build one back, which didn't make a lot of sense. If you go back historically, there was a lot of effort to differentiate C3 from C5 and to have more intense type uses in C5 and be more restrictive in C3. But if you look at the differences between a drive-up window service that has amplified sound or a speaker, and you have compare that to a drive-in restaurant, there's really not much difference. So from staff's perspective, it makes more sense to amend the C3 district to allow drive-ins as well as restaurants with drive-up windows, since they do share many of the same characteristics. We discussed this with the Planning Commission back in September, and they were unanimous in their recommendation that C3 district should allow all types of restaurants, sit-down, drive-up, and drive-in type restaurants. So the attached ordinance amendment would just clarify that drive-in restaurants such as Sonic would be permitted in C3 just as any other type of restaurant. So the recommendation from the Planning Commission was to approve this amendment as proposed.
Isn't most of the downtown zone C4?
Correct.
Most of the downtown is Zone C4. May have lost our map, John, but the Mulberry is kind of the cutoff, and everything south of Mulberry is predominantly C3. So you have a kind of a cutoff line, and C4 doesn't really extend south of Mulberry.
What are the main differences between C3 and C4?
Well, C4 allows for a 0 setback, so the buildings obviously you see in the downtown area have the 0 setback. C4 does not require businesses to provide their own off-street parking, whereas C3 requires buildings to be set back from the street and requires each business to provide their own off-street parking. So those would be the primary differences.
Additional questions to staff? Seeing none, I'll invite any public comment. Commission action?
Mayor, I'd move we adopt ordinance number 07-10425, clarifying the maximum allowable height of ground and pole signs in the C3 and C4 districts.
That's not the,
One ahead of myself.
I'd second that, but that's the next item on the agenda.
Oh my gosh.
Right. So,
From R3, excuse me.
yeah, we're going to,
An ordinance number.
We're on 7.2.
No, now I'm on the wrong
we
one.
want to do ordinance number 07-10424, amending the C3 shopping center district to allow drive-in restaurants as a permitted use.
That's a motion.
Yeah.
Second.
Second. Motion is to approve ordinance 07-10424, amending Salina Code to allow drive-in restaurants as a permitted use in C3 zoned areas. All in favor signify by saying aye.
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 Opposed, same sign. That passes 5-0.
Item 7.3, application number Z07-20, requesting an amendment to section 42-521 to clarify the maximum allowable height of ground and pole signs in the C3 and C4 districts.
Mr. Andrew?
Thank you, Mayor. We're trying to clean up all these C3 items all at once. We may have made it more complicated than helpful, but this is only partially related to this item, but we have in 1990, there was a comprehensive set of amendments to the C4 district sign regulations that were adopted. And the way our code is structured, the C3 and C4 district sign regulations are found in the same section. And when the amendments went to the publisher of the code, there was a printing error in the published code that didn't reflect what was actually in the ordinance before it was amended, and it kept getting republished in different forms, but they never quite got it right. We are now self-publishing, but it seemed like the best way to address that was, since we're self-publishing, was to have this clarifying amendment to state that it was the intent that the maximum height of a pole sign in both C3 and C4 be 30 feet. And for some reason, when the code was published, it kept omitting the reference to C3. So the attached ordinance is really to clean up and clarify that so that the published code that we have will clearly state that the maximum height of a ground or pole sign in C3 is 30 feet. And that has been consistently applied, but it is it just needs to be clearly stated so it can be found in the code.
Any questions of staff on that matter? If not, I invite any public comment. Seeing none, we'll bring it back to the commission.
I can do this. I would move we adopt ordinance number 07-10425, application Z07-20, requesting an amendment of Section 42-5215, clarifying the maximum allowable height of ground and pole signs in the C3 shopping center and C4 central business districts.
Second.
Motion is to approve ordinance 07-10425, which amends Salina Code to clarify that ground and pole signs in the C3 and C4 districts will be limited to 30 feet in height. All in favor signify by saying aye.
Aye.
Opposed, same sign. That passes 5-0. We will continue on at this time with items of administration.
Item 8.1, second reading ordinance number 07-10422, providing the vacation of a 20 feet of platted restricted access along the east side of Lot 2, Block 1 in the Brock Addition.
This passed last Monday on first reading. I'd entertain any additional comments if there are any. Seeing none, entertain a motion.
Mayor, I move that we adopt ordinance number 07-10422 on its second reading.
Second.
Motion is to approve ordinance 07-10422, which vacates 20 feet of platted restricted access in a section in the Brock Addition. Will clerk please call the roll?
Commissioner Larson?
Aye.
Commissioner Peck?
Aye.
Commissioner Perney?
Aye.
Commissioner Vanier?
Aye.
Mayor Joka?
Aye.
Item 8.2, resolution number 07-6450, providing for the advisability and authorizing improvements in the Eagle Crest Twin Homes addition.
Okay. Mr. Place?
Thank you, Mayor and Commissioners. Petition number 4302 was submitted requesting improvements to serve 20 residential lots in the Eagle Crest Twin Homes addition. The petition is signed by the owners of record of more than half of the area liable to be assessed under the proposal, and therefore meets the statute requirements for sufficiency. All costs are to be assessed against the improvement district. Property owners will have the opportunity to pay the full assessment prior to the bond issue. Otherwise, the assessment plus related interest costs will be spread over 15 years in equal annual installments. It is recommended that the City Commission approve resolution number 07-6450 of advisability and authorization establishing the Special Assessment Improvement District and authorize staff to set the bid date for the project. If you have any questions, I'd be happy to answer.
Questions of Mr. Pace?
I guess I could ask one, since he's up there. I see that some of these assessments run over 30,000 a lot. That's a 2-unit lot, though, right, when it's done? Am I understanding that each of those lots that has a $35,000 assessment is actually 2 dwelling units?
Yes, I believe that's correct.
Okay. So otherwise, we're setting a record, I think. Yeah.
Any additional questions? Thank you very much. I entertain any public comment, if there is any. Commission action?
Mayor, I would move for approval of Resolution 07-6450, providing for the advisability and authorizing improvements in the Eagle Crest Twin Homes addition.
Second.
Motion is to approve Resolution 07-6450. All in favor signify by saying aye.
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 Opposed, same sign. That passes 5-0. And I do believe we're going to change the order. 8.4 is going to be first. Is that? Okay.
Thank you, Mayor, Commissioners.
I think we might want to, excuse me a second.
Sorry.
Resolution number 07-6455, authorizing an agreement with Aflac for employee-funded supplemental insurance policies.
Ms. Fisher?
Okay, thank you. Over the past year, several employees have inquired about short-term disability insurance options, and currently we do not offer any short-term disability. There is long-term disability through CAPERS. Because there is a gap there, Human Resources decided to look into some options, And after reviewing proposals from 2 different providers, AFLAC was selected due to lower short-term rates for disability coverage, the accessibility of representatives to come on site and help with the education for the employees, and the potential of flexible spending account administration at no charge. Other popular policies that will be offered in addition are accident and cancer coverage as well. Other than the staff time to process the paperwork and set up any of the payroll deductions, it would not result in any expense for the city because these are employee options only. The employer would not put forth any money. The premiums are submitted at the end of the month of the coverage, so we would not be having any cash flow out there ahead of what we are withholding. And further, the policies other than the short-term disability could be deducted on a pre-tax basis, so there could be some tax savings if any of the policies are purchased for both the employer and the employee. In conformance with the strategic plan, goal number 3, the city will provide the highest quality of services consistent with governing body direction, available resources, and staff commitment to quality. Staff believes that offering of the supplemental policies for employees to purchase is a benefit and a service that can be offered to our employees with very little cost. It is recommended that resolution number 076455 authorizing the city manager to enter into an agreement to offer the supplemental insurance policies for employees is approved. The alternatives would be to go ahead and offer the supplemental policies through AFLAC or to not offer the insurance policies at this time. And I'd answer any questions that you could ask.
Any questions?
Is the long-term coverage through CAPERS elective?
No, that's automatic for anyone who is in the CAPERS program. That kicks in at 180 days.
Okay, so you don't have a choice there.
It's mandatory.
Yeah, it's part of the plan.
And then the AFLAC would stop once the CAPERS kicked in?
Right, and that is mandated. That's something I looked into. We are not allowed to offer it past 6 months, to offer short-term. I spoke with our insurance consultant. He said he'd found that out recently, that we could not go short-term. Once the short-term policy would have to end at 6 months, and at 6 months it becomes long-term and would be covered by CAPERS.
Which do they pay more for, AFLAC or CAPERS?
Well, it would be through the 4% deduction for CAPERS. I say CAPERS, I believe KPNF also has some similar coverage. CAPERS is what I looked into, and that's what I've been familiar with since we've had a couple of employees that have had to be moved to the long-term disability recently. But it's part of that 4%, so...
You don't know what the breakdown is then?
I don't know specific percentages. You mean as far as who pays more? Or what does the employee pay out? The employee in their 4% is covered as a result. There's no additional policy that they would take on. Through AFLAC, the short-term disability, it would be purely an election that they are purchasing on their own. So it's a tie-in benefit. On the retirement side, the 4% covers, from my understanding, whereas this is a separate policy that they are purchasing, if that makes sense.
So if they elect to do it, then this is withheld from their check for 6 months and then it stops, right?
No.
No, the policy it's just, you take out an insurance policy that I want to be covered in the event something happens to me.
They have to be disabled for 6 months.
Right, and there's different definitions of a short-term versus long-term. For instance, someone who is expecting could qualify pending the duration of the pregnancy and the recovery thereafter. So, they would just have some income in that interim. Say if someone is out of work and deemed short-term disabled for 2 months, they would still have some income coming in. It would protect them rather than be so severe as to they can't work for 6 months or more. There are different levels of coverage that the employee could take out, 7 days, 14 days, 30 days, different structures to where they could adjust and pick how much they wanted withheld. And that, again, is an employee option. But since we have a fairly generous sick leave and vacation policy, that's one of the things we would work with the representatives to really maybe not want people to focus so much on being looking at those higher rates that would kick in after 7 days of a short-term disability.
Okay, thank you.
Sure.
Any additional questions of staff? Thank you very much. I'd entertain any public comment if there is any. Seeing none, I'll entertain a motion.
Mayor, I'd move for approval of Resolution 076455, authorizing an agreement with AFLAC for employee-funded supplemental insurance policies.
Second.
Motion is to authorize Resolution 07-6455. All in favor signify by saying aye.
Aye.
Aye. Opposed, same sign.
Item 8.3, resolution number 076454, authorizing an agreement with AFLAC to administer Section 125 flexible spending account.
Ms. Fisher.
Okay, thank you again, Mayor and Commissioners. As an add-on to the item we just discussed, as we looked into the process, it was proposed by AFLAC that they would they could administer the flexible spending account at no charge. The city has offered a Section 125 flexible spending account for over 10 years. The benefit allows employees to designate different dollar amounts on a pre-tax basis for unreimbursed medical expenses and dependent care. We don't have any problems with our current provider, but after running the figures on what the administration could be at no charge, we looked at potential savings of $10,560 annually based on our current enrollment. So, wanting to take measures to save money without compromising the benefits offered to employees, we thought it would be worth a try to see if they could effectively and, I guess, quickly administer that same account. Recommend that we approve the resolution number 076454, authorizing the city manager to enter into an agreement with AFLAC to administer the Section 125 flexible spending account. And we could either authorize as an alternative AFLAC to administer it at no charge, or another alternative to continue using our current provider and continue to pay the fee. And again, I'd be happy to answer any questions.
What happens if AFLAC changes its mind at some point and doesn't want to do this for free anymore? Or is there a guaranteed term on this?
Well, the Section 125, we look at an annual that coincides, an annual agreement that coincides with our benefit year, and we currently run it February 1st through January 31st. If that were the case, then we would look at another provider.
So this could be as little as a one-year agreement?
It could be. I do have an AFLAC representative here if you would like to answer the question.
I just wondered if it was contingent on the dollar volume that they're going to be able to generate off this supplemental insurance policies or some such a thing.
In my history.
Ma'am, we might. If you can give us your name and address also.
My name is Jody Hipp with AFLAC. I've been with AFLAC for 7 years, and in the history of my time and service with the company, there's never been a situation where we have withheld or withdrawn that offering. Once we've entered into an agreement with the account as far as the flexible spending administration for free at no charge, that not saying it cannot change from AFLAC's end, but so far in history, it has not changed. Typically, it's if the group would decide to make a change to the third-party administrator that they choose. It definitely is a one-year, for sure, agreement. And like Commissioner Perney said, it could be as short as 1 year, but if history stands, the agreement is there as long as both parties agree to it.
Okay. Thank you.
Is this the monthly deduction a set amount, or do they submit receipts to you and then are reimbursed from those receipts?
The process is, if you don't mind, the process is standard. They submit their documentation as far as summary of claims process, prescription receipts, whatever it might be, with a request for reimbursement form that they submit to AFLAC at a toll-free fax number. And then we process on a daily processing. And so every day that we're receiving those requests, we're processing those and administering the reimbursements to the employees. We also do offer a direct deposit capability. So typically they're experiencing their reimbursements faster than what they're used to.
Okay, so this isn't a process where they have so much money taken out of their check, and then at the end of the year, if they don't spend it, you keep it?
Yes, that is the process. However, AFLAC does not, it is a use it or lose it program.
It is a user, and
And
the
those-
employees know that.
That's what we currently have.
That's an IRS regulation. That's not specific to the companies. And that money actually stays with the city of Salina. It's not funds that AFLAC attains. If
Well,
there's
either way, they lose it.
correct, but it is, the idea is that it's a tax savings for them. So
Is that on a calendar year?
the group sets it, so it'll be a February 1
February.
renewal.
January 31st.
Commissioners, just really quick to clarify that question. It kind of works both ways. It depends on the scenario. But if you're an employee and you participate in the program, you're going to be putting in money at an equal amount each month into your account. If you have an illness or a cost that qualifies early in the year, you don't have to have the fund level at the time you want to get your reimbursement. You can, for example, let's say you're going to put $1,000 in over the full term of the year, but your medical cost is say $800, and you want to do that early in the year, and you've only put in $200. It doesn't matter. Once you set your account up for that amount, you're able to, in essence, spend that or get reimbursement on whatever amount up to that $1,000 anytime during the year. So that there's kind of the dual-edged risk. One risk is as an employee, you go in and you say, well, I want to participate, but I'm not sure how much because I can't anticipate all my health costs that I might have. So you try to guesstimate the best you can. If you put too much in and you don't use it, you leave it on the table and it stays in our account. If you put money in, you use it early, and then for whatever reason you separate employment, then we actually lose that. So it can work either way. Our history shows that it's been on the positive, not by a lot, but in the positive on our side, just based on the patterns that we've had. But that's how the system actually works.
Thank you very much. Any additional questions? If not, I'll entertain any public comment. Don't see any, so we'll entertain a motion.
Mayor, I'd move that we authorize or approve resolution number 076454, authorizing the city manager to enter into an agreement with AFLAC to administer the Section 125 flexible spending account.
Second.
Motion is to approve Resolution 07-6454, authorizing agreement with AFLAC to administer Section 125 flexible spending account. All in favor signify by saying aye.
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 Opposed, same sign. That passes 5-0. I believe we do have an motion for an executive session.
Oh, no. Oh boy, I get to do this. Okay, I move the City Commission recess into executive session for 30 minutes, although this says 15, but we've never made one yet, to discuss with legal counsel matters subject to the attorney-client privilege for the reason that public discussion of those matters would waive the privilege, and to discuss confidential data relating to the financial affairs and trade secrets of a corporation for the reason that public discussion of the information would competitively disadvantage the corporation, and reconvene in this room at 10 minutes after 5.
If I may interrupt briefly, Mayor.
I can't do that.
Well, I know, as between the city manager and the city commissioner, I know who wins. I know
Okay.
that much. But the only
Okay,
point I would make
15
was we do have to, as long as we go in, we have to stay. So,
Okay. Oh, I didn't understand that because we've never been done early. Okay. Make it 15 minutes and 5 minutes till 5.
Second.
Motion is to go into executive session for 15 minutes. Before I call for vote on that, is there any action anticipated afterwards?
There's not.
Okay. Motion to move into executive session for 15 minutes. All in favor signify by saying aye.
Aye.
Aye. Opposed, same sign. We will move into executive session.